Welcome to the Deep Dive. We're here to explore those really tricky areas in the law and, well, give you the clear analysis you need. Today we're diving into something incredibly serious. What happens legally when a death isn't intended? We're going to map out involuntary manslaughter, looking at the two main ways common law turns a tragedy into a crime. And then we'll tackle the really complex issue of assisting suicide.
That's right. It's a whole different ballgame when there's no intent to kill. The big challenge for you listening is figuring out exactly how careless or how at fault someone needs to be for the law to step in criminally. So we need to clearly define those two routes. First, there's a criminal negligence path, recklessness focusing on the person's mindset and the risk involved. And second, there's the, well, older but still kicking unlawful act doctrine, sometimes called misdemeanor manslaughter, which often ignores the mental state and just looks at whether a lesser crime was being committed.
Okay, let's unpack that first one. Reckless killings. When someone's carelessness causes a death, where's the line drawn? We know ordinary negligence. The standard for, say, a lawsuit usually isn't enough for a criminal charge. So what is the criminal standard?
Yeah, it's got to be more than just simple carelessness. Much more, actually. Generally, this something more means the action involved either, one, a high degree of risk of death or really serious injury, like a major, obvious danger, and/or two, the person must have actually been aware of that risk and just ignored it. That second part, the awareness, that's what modern laws, like the Model Penal Code, usually call recklessness. It's about consciously disregarding a risk that's substantial and, frankly, unjustifiable.
Okay, so the law has to deal with two kinds of people then. The one who creates a huge, obvious risk, but maybe is just completely oblivious to it. And the one who knows the risk, sees it clearly, but goes ahead anyway. Let's start with the first type, the objective standard. And there's a really tragic, famous case for this, Commonwealth v. Wolanski. To really get how this objective standard works, we should probably break down the court's logic step by step.
Absolutely. It's about looking at the conduct itself, not just what was going on in their head.
Let's analyze Commonwealth v. Wolanski. First, what are the legally dispositive facts?
Okay. The defendant owned a very popular nightclub, the Coconut Grove. He failed to install proper fire exits or keep them usable. A fire broke out, and tragically 490 people died. So this death was caused by an omission, a failure to act.
And what was the core legal issue?
The big question was, could he be convicted of manslaughter for this failure to act, even if he argued he didn't personally realize just how incredibly dangerous the lack of exits was?
What rule did the court apply?
The court said the standard really hinges on the gravity of the danger. If a reasonable, ordinary person in the same situation would have realized how massive the danger was, then the defendant can't just get off the hook by saying he was stupid or heedless, as the court put it.
What was the court's analysis?
Well, the analysis really zeroed in on the objective situation. Failing to provide safe exits created this incredibly high, grave danger for a huge crowd of people. That conduct itself, regardless of what the owner specifically thought or didn't think, was considered wanton or reckless omission.
And the conclusion?
The conclusion was that the manslaughter conviction was correct. It was based squarely on the objective, grave danger created by his failure to act.
Okay, so that covers the oblivious defendant creating objective danger. Now let's flip it. What about the person who has some kind of personal issue, a defect, that makes their actions especially risky, and crucially, they know about it? This brings us to People v. Decina.
Yes, Decina. This is really the textbook case for subjective awareness, especially when it's tied to a physical condition.
Let's analyze People v. Decina. First, what are the legally dispositive facts?
Right. So the defendant knew he had epilepsy and was prone to sudden, unpredictable seizures. Despite knowing this, he chose to drive a car. He then had a seizure while driving, lost control, the car went onto the sidewalk and killed 4 children. A terrible outcome.
And what was the core legal issue?
The issue was, did his knowledge of his condition, combined with the act of driving anyway, amount to the kind of recklessness needed for a homicide conviction?
What rule did the court apply?
The court basically said that a known physical problem, like epilepsy here, is treated as one of the circumstances you have to consider when asking if the defendant acted reasonably. Reasonably under those specific circumstances, which include knowing about the defect.
What was the court's analysis?
The analysis focused on the idea of a conscious choice. Because the defendant knew the risk associated with his seizures, the court said he deliberately took a chance. He made a conscious choice of a course of action, getting behind the wheel. That prior knowledge was the absolute key factor showing he consciously disregarded a massive risk.
Yeah, the conclusion.
The conclusion was that he was guilty of causing death by reckless or, as they put it, culpably negligent driving.
So the law seems pretty clear then. Whether the risk is obvious to everyone, like in Wolanski, or mainly known just to the defendant because of their condition, like in Decina, if the risk is grave enough and it's disregarded, consciously or unconsciously when it should have been obvious, criminal liability can follow. But let's circle back to that omission point from Wolanski. What really separates a criminal failure to act from just, a moral failing, like watching someone drown versus failing to provide care?
It really boils down to one thing: a legal duty to act. For manslaughter by omission, the prosecution must prove there was a specific legal duty. This usually comes from a recognized relationship, like parent-child, or maybe a contract, like a lifeguard or a railroad switchman, or sometimes a statute imposes a duty. If that duty exists, and the failure to act involves criminal recklessness, the law treats it just like a reckless action that caused death. That's why, for instance, a parent who relies solely on prayer instead of getting medical help for a very sick child can sometimes be found guilty of manslaughter. They have a clear duty to protect their child. But on the other hand, the bystander who sees a stranger drowning, morally awful, maybe, but generally, there's no legal duty to rescue, so no criminal liability for just standing there.
Okay, that clarifies the recklessness track. Now, let's tackle the second major route to involuntary manslaughter, the unlawful act doctrine, sometimes called misdemeanor manslaughter. This one seems, well, potentially much broader, maybe even harsher. How can causing a death during a simple misdemeanor, something less serious than a felony, end up as a manslaughter charge?
You're right, it can be quite harsh. This doctrine is a holdover from older common law. Basically, it says an unintended killing that happens while someone is committing an unlawful act, specifically one not serious enough to be a felony, is automatically manslaughter. It's almost like strict liability for death if you were doing anything illegal at the time, even something minor. Now, a lot of states have gotten rid of it because it can lead to some weird results, but about half the states still have it on the books in some form. And unlawful act can cover a lot misdemeanors, like simple battery, traffic offenses, even things that historically weren't even crimes, like attempted suicide in some old cases.
Right, I could see how that could get out of hand. Like, could you really be charged with manslaughter if someone died coincidentally while you had an overdue library book? Courts must have put some limits on this, right? You mentioned a key distinction courts use, malum in se versus malum prohibitum. Can you break that down for us?
Absolutely. This distinction is critical for understanding the limits. Malum, in se, refers to acts that are, inherently wrong or evil in themselves. Think assault, battery, theft, things most people would agree are just wrong. Malum prohibitum, on the other hand, refers to acts that are wrong only because a law says they are. They're regulatory or administrative offenses, like driving without a license or maybe a minor zoning violation. It's not inherently immoral, just forbidden by statute. So to stop the doctrine from being totally absurd, courts started applying stricter limits, especially when the underlying unlawful act was merely malum prohibitum.
Okay, and what are those limits for the malum prohibitum acts? I recall there are three main views, but you mentioned one that seems particularly designed to link the illegality to the death itself.
That's right. The three main ways courts limit it for malum prohibitum offenses are: 1, requiring that death was a foreseeable result of the unlawful act. 2, requiring that the death was actually caused by the unlawful excess of the conduct, the part that made it illegal. Or 3, some courts just say the conduct still has to amount to criminal negligence anyway, which kind of merges it back into the first doctrine we talked about. But view number 2, the unlawful excess rule, is really interesting. It basically forces the prosecution to show a direct causal link between the illegality itself and the resulting death.
Let's put that unlawful excess rule to the test with a case. People v. Penny.
Okay, let's analyze People v. Penny. First, what are the legally dispositive facts?
All right. You had an unlicensed cosmetologist who gave a client a facial treatment, like a facelift procedure. The treatment involved a chemical that turned out to be toxic, and unfortunately the client was poisoned and died. Practicing cosmetology without a state license was a misdemeanor in that state.
And what was the core legal issue?
The issue was, could the fact that the cosmetologist didn't have a license, the malum prohibitum unlawful act, be considered the legal cause of the client's death under this misdemeanor manslaughter rule?
What rule did the court apply?
The court applied that specific limiting rule we just discussed. The death must be caused by the unlawful excess, meaning The prosecution had to prove the death resulted directly from the part of the conduct that was actually illegal in this case, the lack of a license.
What was the court's analysis?
Well, the court looked at it and found it extremely dubious, I think was the phrase, that the simple lack of a piece of paper, the license, had any causal connection to the death.
The actual cause of death was the dangerous chemical treatment itself. Using a dangerous poison could have happened whether the person was licensed or not. The administrative failure, not having the license, didn't cause the poisoning.
And the conclusion.
The conclusion was clear. No manslaughter liability based on just the misdemeanor of practicing without a license. If the state wanted a manslaughter conviction, they'd have to prove reckless manslaughter, showing the application of the poison itself was criminally negligent, regardless of the license status.
Okay, that makes sense as a limit for those regulatory type offenses. But now, let's look at the other side. The malum in se acts, the inherently wrongful ones. Consider the classic thin skull scenario. A person intends just a minor push or maybe a light slap, technically a simple battery, which is malum in se. But unknown to them, the victim has a hidden vulnerability, like an unusually thin skull or a weak heart. The light contact causes an unexpected fatal injury. Death was totally unforeseeable from such minor contact.
Right, and this is where the doctrine shows its really harsh side. Because simple battery is considered malumphu inherently wrong, the general rule is that if death results, even completely unexpectedly, it's involuntary manslaughter. The fact that the defendant intentionally committed the bad act, the battery, dramatically lowers the bar for holding them responsible for the unforeseen death. It's a stark example of how doing something viewed as inherently wrong makes you liable for consequences far beyond what you intended or could have predicted. It can lead to outcomes that feel disproportionate, but it reflects a strong legal policy against causing death during wrongful acts.
Okay, let's shift gears again to a related but distinct area. Assisting suicide. Suicide itself isn't a crime anymore in most places, but the law comes down hard on people who get involved in someone else's death. So where's the line drawn? When does helping someone end their life become manslaughter, or maybe a specific crime like aiding suicide, versus becoming actual murder?
The key distinction usually comes down to agency, who is ultimately performing the final, fatal act. So if person A uses force, threats, or maybe deception to make person B commit suicide, that's typically murder. Likewise, if person A is the one who physically performs the act that causes death, like, say, administering a lethal injection at person B's request, that too is almost always treated as murder, because A is the direct cause, the agent of death. But if person A's involvement is more indirect, maybe providing the means, like pills or information, or offering encouragement, that usually falls into a different category. It might be a specific crime defined by statute, often called aiding suicide, or sometimes it's treated as manslaughter.
That line seems like it could get really fuzzy, especially in situations like suicide pacts. What about the case Neary, Joseph G? Their two friends make a pact, they drive a car off a cliff together, but one survives. The survivor was the one driving, the active force causing the other's death. Why isn't that considered murder?
Ah, yes, the suicide pact scenario. This is generally seen as a critical exception. The reasoning is that when two people genuinely agree to die together, and they undertake simultaneous actions where they both face an identical risk of death, well, the courts tend to see this differently. The shared agreement and identical risk kind of negate the idea of one person overpowering or deceiving the other. So in a true suicide pact like that, even if one person was technically the driver or operated the means, the survivor is usually found guilty only of the lesser crime of aiding suicide, not murder. It acknowledges the unique, shared nature of the decision.
That's a really specific exception. Now, thinking about defenses, if someone is charged with assisting suicide, just by, say, encouraging the person, can they argue that the victim's own choice to die breaks the chain of causation, that the victim's act was an independent decision? Do courts buy that? And stepping back, what's the overall legal status here? Is there any kind of constitutional right involved in assisted suicide?
Courts are generally pretty skeptical of that intervening cause argument in suicide assistance cases. Prosecutors often defeat it by presenting evidence showing the victim wasn't fully acting freely. They might show the victim was particularly vulnerable, maybe depressed, or that the defendant exerted significant pressure or influence, effectively overcoming the victim's will. Think of the Commonwealth v. Carter case involving text messages. The court found the encouragement was a substantial factor. As for the constitutional question, that's quite settled now. The Supreme Court addressed it directly in Washington v. Glucksberg back in 1997. The court ruled definitively that there is no constitutional right to assistance in committing suicide. States are completely free to prohibit it. They have legitimate interests in doing so, like preserving life, protecting vulnerable groups, the elderly, disabled, people under pressure, and avoiding the potential slippery slope towards non-voluntary euthanasia. Hashtag de-exam framework synthesis. Concluding section.
Wow, okay. We've really covered a lot of ground here, mapping out how the law assigns fault when death is unintended, from reckless omissions to deaths during minor crimes, and finally this complex area of assisted suicide. To help pull all these threads together, especially for someone facing an exam or needing to analyze a situation, what's the practical step-by-step diagnostic checklist you'd offer? How should someone approach spotting these involuntary homicide issues?
Absolutely. Having a clear framework is key. Here's an actionable diagnostic checklist to run through. Step 1, classification check. First things first, is the homicide intentional? If yes, you're looking at voluntary manslaughter or murder. If it's clearly unintended, then proceed down the involuntary path. Step 2, omission check. Was the death caused by failure to act? If yes, you absolutely must ask, did the defendant have a recognized legal duty to act? This could be from a relationship, a contract, or maybe a statute. If there's no legal duty, liability for omission generally stops right there. Step 3, reckless manslaughter track. Okay. If it was an action or an omission with a duty, did the conduct involve an unreasonable risk of death? If yes, now apply the two key tests we discussed. A, was there a high degree of objective risk? Would a reasonable person have seen the grave danger, Wolanski? And Ador, did the defendant have subjective awareness of that risk and consciously disregard it, Decina? A, yes, to either A or B, depending on the jurisdiction's standard, points strongly towards criminal negligence manslaughter. Step 4, unlawful act manslaughter track. Right. Was the killing committed during the commission of some other unlawful act that wasn't a felony? If yes, you have to figure out. A, was the underlying act malum insitio, inherently wrong, like battery? If so, manslaughter liability is very likely, even if death wasn't foreseeable. Remember the thin skull rule. B, or was the act just malum prohibitum, wrong only because prohibited, like a license violation? If malum prohibitum, you must apply the limits, especially the unlawful excess causation rule from Penny. Did the illegality itself cause the death? Or does the jurisdiction require foreseeability or even separate proof of criminal negligence? Step 5, suicide analysis. Finally, if the facts involve assisting a suicide, pinpoint the defendant's role. A, did the defendant use force, duress, or were they the actual direct agent of death? e.g. administered the fatal dose? If yes, it's almost certainly going to be charged as murder. B, or was it part of a simultaneous identical risk suicide pact? If yes, that's the exception, often leading only to the lesser charge of aiding suicide.
That synthesis really lays out the different legal paths and hurdles. It highlights just how carefully the law tries to calibrate blame when intent to kill is missing, demanding proof of significant fault before turning an accident into a serious crime.
Exactly. And that complexity really underscores the ongoing debate highlighted by the Glucksberg decision. You see, if a state does decide to legalize something like physician-assisted suicide, the huge challenge becomes drafting laws that truly protect those who might be vulnerable: the poor, the elderly, the disabled, people perhaps feeling pressured. How do you protect them without infringing on the autonomy of a mentally competent, terminally ill person who genuinely wishes to hasten their death? It constantly brings us back to that fundamental tension, balancing the state's powerful interest in preserving life against an individual's claim to control their own end. It's a question with no easy answers.